What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to take a look at Lori Vallow's cross examination, day one. And we are going to try to watch some of today live to get the cross examination she is going to do before lunchtime there. It's on a tape delay. The timing differences between where I am and where the case is make it kind of difficult to get the perfect time of when to do these streams. So if you guys are catching this live, awesome. I want to answer your questions. If you're watching it at the end of the day or sometime at night, that's awesome. I will read the comments to get your questions, but we're going to dig in, see how she's doing. We took a long time talking about her opening statement yesterday, but that is just a small part of the case. Cross-examination and the way she questions witnesses and the information and evidence that she can pull from witnesses that will not be friendly to her on that witness stand, that's going to be incredibly important. So let's take a look together at how she did. So a lot of these witnesses, especially early in the case, are going to be law enforcement, first responders that show up to the scene. They set the scene, who was where, what they saw, where the body was, how it was positioned, what they think happened, what they think don't, what was actually said over the 911 call. And we'll get into some of those details, but these officers are laying the foundation, building the background, building the timeline through the prosecutor. Again, I wouldn't say it's the most overly engaging presentation of evidence I've ever seen, but they are checking all the boxes, getting all of the information. It is weird to think in the back of my mind that even after doing all this, they came to the conclusion that it was self-defense for quite a while. We know that a lot of that was based on Tylee's testimony and what she said happened. So how is that going to get in front of this jury still remains to be seen. But the way they're answering the questions today surely seems like they knew something was wrong. They knew something was off, especially based on the demeanor of Alex Cox. The injury to his head, what he did and didn't do, didn't seek medical attention, things like that, what he said, what he didn't say, didn't act how they would expect him to act. And those were some of the, high points and highlights of the direct, which is a good indication that Lori Vallow picked up on. That is important, and this is what they're trying to prove. But what can she actually do with it in her questioning? Let's take a listen.
You said that the individual exiting the house was nonchalant. Is that correct?
I don't know if I use those words, but he seemed very calm, yes.
Very calm.
Yes.
Is that the same thing to you as nonchalant?
I wouldn't use that word, so I would say he looked very calm and unbothered.
But you said nonchalant a minute ago.
I don't recall saying that.
Okay.
I believe he actually did say nonchalant. I do believe he said that. And I also don't know why he cares if he says it again. That's the point, is that he was nonchalant. Sometimes witnesses feel like they have to argue with defendants or defense attorneys when I think that's your good point, that he was nonchalant in a very strange situation.
Does everyone act the same in a stressful situation that you've experienced? No. Are you qualified to give someone a psychological evaluation?
No.
No. You put your hand on my husband's neck for checking for a pulse. Is that correct?
Yes, ma'am.
That's what you did when you first came in?
Yes.
Did you perform CPR?
No.
No. Why not?
Because it was apparent to me that he was deceased.
And that's not.
Which is interesting when you compare it with some of the first responders, how apparent it was that he was deceased, to this officer that responded on scene, I should say other first responders. But did you do CPR? Like almost putting the onus on him, right? Some weird questions that don't really make sense, that I don't think a lawyer would necessarily ask, that she's asking, like, well, I'm supposed to do CPR, but you're not?
Not your protocol
To what?
to perform CPR until fire comes in?
Not if it's going to make it even worse because they had apparent gunshot wounds to the chest.
And what do you mean by that?
Well, if I start pumping on his chest, it's going to start spewing blood out of his chest even at a more rapid pace.
So he basically says you shouldn't do CPR, which again, I think is different from some of the other first responders that testify. But showing inconsistencies between prosecution witnesses, maybe that's a good point. Will it be enough? I'm not sure.
So when the 911 operator was telling my brother to do that, that same thing would happen?
All depends on when the call came into dispatch.
But I'm saying if you're doing CPR on someone with a gunshot wound in the chest, on the chest.
Could, yes.
Yeah. Okay. And you said something else. You said fire gives official time of death. Is that correct?
Yes.
Okay. And what was that time of death? Do you know?
I do not recall.
And you cleared the house before fire came in. Is that correct?
Yes, ma'am.
Okay. And you were looking for some kind of identification?
When I
Yes.
cleared the house,
Yes.
I was looking for other potential victims and or suspects.
Okay. But you were told on the phone that no one else was in the house but Alex. Is that correct?
I don't recall if I was told that or not.
Okay. Do you have any crime scene investigation experience?
Just my 20 years of experience as a police officer.
Do you have any crime scene investigation experience? Only 20 years of being a police officer. So again, if she was trying to get into technicalities of where blood would be or blood spatter, or something that's very technical, she could dig in a little bit there. But a cop who responds to situations like this, his experience to responding to situations like this is 20 years of responding to situations like this. So you can feel a lot of, she's definitely not dumb. Okay. I think she is a smart lady. She's paying attention to what's being said. She's taking notes, but she's not a lawyer. So connecting the dots or hearing a lawyer ask certain questions in her other trial or in hearings where they may question law enforcement, hearing the questions they ask and writing it down and asking the same question, or even having standby counsel tell you, here's a good question to ask, then actually executing it and it being effective are two very different things.
And you said something about, and this is just for me to understand, you said something about the casings being to the left of him or to the right of him?
I didn't say they were to the left or to the right.
Oh, did you say west or east?
No.
Oh, sorry, that was my interpretation. Can you tell me what the weapon was that you found?
It was a handgun.
Was it a 45?
Don't recall.
Okay. Could you tell what direction the bullet came from?
Based off the way the body was laying, I could assume it came from where his feet were at.
Near the feet?
Mhm.
Did you see the projectile that was in the baseboard?
I don't recall if I saw that or not.
You said he did not appear alive, that you already thought that he was deceased. Is that correct, when you entered into the house?
Yes.
And what time was that?
I believe I was dispatched to the call at 8:41. So I mean, if I was going to make a guess on what time I walked into the house, I would say I was probably at the residence within 10 minutes.
So around 8:51, perhaps?
Possibly, yes.
Okay. And then when fire took over, is that the normal protocol for fire to take over and do the CPR?
Yes.
And so you didn't do CPR, but they did do the CPR. Is that correct?
Yes.
On top of the gunshot wound.
Yes.
Is that normal protocol?
I don't know what their protocol is.
Okay. I'm just asking because I wouldn't think to do that either. And then you said that you went outside to put up the crime scene tape. Is that correct?
Yes, ma'am.
So after you cleared the house, you left and went to the front yard?
Yes.
And then you were there for how long at the residence before you left?
I couldn't give you a time.
Did you stay for a while, or was that the end of your job there?
I don't recall. It was a long time ago. I have no idea how long I was actually on scene for.
And who is your direct supervisor?
I believe that day was Sergeant Nocella.
I'm sorry, what was the last name?
Nocella?
Okay.
So another thing I noticed here during her cross-examination is it felt a little bit like a deposition, like a young lawyer doing a deposition, getting information that she doesn't have, that she doesn't know. A lawyer in this situation would have a lot of these details, would understand where to find them in police reports, or if they take depositions, or if these witnesses have already given statements, they would already have a lot of this information. She's asking for confirmation, new information. I think she's taking notes. I think she's going to try to point out the differences between some of these witnesses. So I think there is somewhat of a method to her madness. I'm not sure, again, how she's going to execute it based on how these first couple witnesses have gone.
And what contact did you have with Detective Moffat that day?
I don't know if I had any with him on scene.
Okay. What about Detective England, perhaps?
I may have briefly spoke to her while I was on scene.
Okay. 1 time, 2 times, 3 times?
I couldn't tell you a number.
Okay. And then when you have to report to your superior before you left the scene?
He was on scene, I would imagine.
Nocella? Is that
Yes.
what you said? Okay. And then you don't know what time you left, but you arrived at approximately 8:51?
Give or take, yes.
And then did you see me arrive at the scene?
I think as I was leaving, yes.
All right. So now we start to get into how she's going to deal with the third person stuff, right? It's like she's asking questions. She can't testify. As a lawyer, you can't testify in your cross-examination. You can ask questions, and that's going to be something that as a prosecutor, you don't want to object too much, but you can't let her get away with testifying through her questions and asking about things that are absolutely inadmissible and bad for your case. If they're inadmissible, but good for you, and she's asking them and opening the door, sometimes you just kind of let that go because you don't want the jury to think you're bullying a pro se defendant. So you've got to be very careful the line you walk.
Approximately around the time that I arrived, you were leaving.
I don't know if I left when you arrived, but I was on my way out of the crime scene as far as I know.
Okay. And then you said something about 2 wounds. Is that correct?
Yes,
And how did you see the 2 wounds through the shirt?
just was an observation that I made when I saw him laying on the ground.
So did you see 2 holes in the shirt?
I'm not sure exactly what I saw when I was there, but I could see that there were 2 apparent gunshot wounds to his chest.
And then I'm sure, well, I won't speak for you. So when they began CPR, they did open his shirt. Is that correct?
I have no idea.
Because when you walked by, his shirt was open.
Objection to question.
Yeah, please ask questions only.
Did you,
So that's kind of a statement, but lawyers do that sometimes, or they say a statement as a question. That wasn't necessarily her testifying, but we're getting close. Let's make sure we nip it in the bud. More coming.
discuss this case with Sergeant Nocella?
I don't believe so. I would imagine he was on scene and he got briefed by the detectives.
He got briefed by the detectives? Is that what you
In
said?
fact, I would imagine, yes.
Okay. And then have you spoken to the case agent on this case? How many times would you say?
Who's the case agent?
Oh, Detective Duncan, that's my
Detective
understanding. Mhm.
I mean, I've spoken to him many times in my career.
Regarding this case, how many times do you think you've spoken to Detective Duncan?
I couldn't even put a number on it. I would say very few.
Very few? Like, how many would you guess?
I would say maybe 5 times.
5 times. Thank you. And would that be in-person kind of discussions or?
Yeah, I wouldn't even say they were discussions, probably just in passing.
Okay. So how many times have you emailed with Detective Duncan concerning this case?
Objection to relevance.
Overruled, you can answer if you know.
I have no idea.
What about text messages?
I mean, anytime cops are talking about a case, I would argue it's relevant, especially if they're getting their story straight, especially if it was self-defense and they talked about it a ton and did a very thorough investigation and determined that it was self-defense for 2 years. That type of stuff I think is really important.
No idea.
Phone calls?
Ma'am, I have no idea.
Okay. And your report that you wrote about this, about how long after the incident did you make your report?
I was done by the end of my work shift at 4 o'clock.
And then did you ever make any revisions to that report?
I don't believe so.
So you left the scene approximately sometime in the morning, and by 4 o'clock that day you had written your report. Is
Yes.
that correct? And you've never changed anything on your report?
Not that I recall, ma'am.
And the report is exactly as you left it did you review it for this testimony today?
Yes.
And it was exactly the same as when you wrote it at 4 p.m. on July 11th?
I don't know if I wrote it at 4 p.m. It was
Or
done
by 4 p.m.
It appears to be, yes.
Okay. Thank you. That's all I have.
All right, redirect.
All right. That was our first, pretty short and sweet. The next one is longer. Before we get there, I'm going to answer some of your questions, but let me jump ahead to that right around, this mark here. Azam said, Peter, how to differentiate direct, cross, and deposition really? So there's tons of differences. Direct, you can't ask leading questions. Cross, you can. You box them in. Cross is kind of short and sweet. You want to know exactly what the answer is going to be before you ask the question. In depositions, that's where you determine information and you find out information, and just about anything's admissible in a deposition. If it's potentially going to lead to something that's relevant, you can ask about it. You can ask about so much more in a deposition than you can at a trial. A trial is only what is admissible, obviously. At trial, that's all you can ask during direct and cross. So very different. All 3 of these are very different, and I'll try to focus in on it as we talk about direct and cross with all the trials coming up this year. And Azam, happy birthday tomorrow for me, but today for you, I think, if I have the times correctly. Thank you, Chris, for letting us know. So happy birthday to Azam. Thanks for spending at least part of it with us. Surfing the Darkness said, the whole point here really is she's doing a decent job, as good as is possible, not even close to how a lawyer could, though. And I think that this is a great comment for where we're at so far in the trial. We'll see how it goes as we continue. But yes, she's doing about as good as you can hope for a pro se defendant with her facts, right? She can't do much about her facts now. She could have done something about them before all this happened, but this is the hand that she dealt herself, and that's what she's dealing with. She is not doing horribly. She's not falling all over herself. She's not bumbling, fumbling, mumbling around. Is she making any headway and making any points? I don't think she did much with that witness. We'll see if she does any more with this witness. I think she did make some points in her opening statement. She opened the door to some problems potentially, especially if what she said is not true. So from my perspective, I would tend to agree that she is doing a decent job. Nowhere near what a lawyer could do. Because a lawyer, it's not just about how well you sound or how good you sound or how well you connect one sentence with the next or how well you present. And it's like, oh, look at my nice suit. And I'm going to build rapport with this witness. It's what points are you getting out? What evidence are you pulling from this witness stand? What evidence are you attacking from the witness stand that's not as reliable as the state wants you to think? And why does that matter legally when you go to make the arguments to the jury? Lawyers do a lot more than just speak. They're a lot more than just a mouthpiece to say words. You have to connect them, give them purpose, and show the jury why they should be with you and see it your way. That's what's so important about, a lawyer's job in a trial. But I will agree, she's doing a lot better than I expected and better than any pro se defendant I have seen to date. I will just say that. All right, let's listen to the second witness she crossed.
Correct?
At the time, yes.
At the time. Okay. Thank you. Thank you. Appreciate it. You mentioned about Alex being calm when he exited the house. Is that correct?
Yes,
And then you were advised that he had told the 911 operator that he composed himself and then called 911. Is that correct?
I don't remember the compose himself, but
So basically she's saying he was freaking out, but even the 911 operator told you he composed himself, then he called 911. So what she's doing here, this actually does have a purpose. Does it make sense? Will the jury buy it? I don't know. But what she's saying is the state's making a big deal about the 45 minutes he waited to call 911 after you shot somebody, which is a very bad fact. And she's trying to twist and use that fact and say that 45 minutes, he was freaking out, didn't know what to do. But once he composed himself, he called 911. Once all you guys showed up, it was after he had 45 minutes plus to compose himself. That's why he was more calm and nonchalant, because he was freaking out right after it happened. It's a theory. It's an argument. It's making a point with her questions, right? I don't know if the jury's picking that up, but
I think he did.
But you stated in your report that Alex was very calm throughout the entire time talking with him, correct?
Yes,
And the scene itself, was it chaotic?
no,
Were people running around screaming?
no,
Were people running in and out of the front door?
no.
So were the officers calm?
It was just me and another officer.
Were you calm?
Yes,
Was the other officer calm?
he was.
Were the detectives calm?
another kind of good point. The scene was calm. The officers were calm. Everybody else was calm. Now, the note that I wrote was, did anybody else just shoot their brother-in-law? Because that might change your demeanor a little bit. But again, I think once she asked this line of questions, she just should have moved on. But she made the mistake that a lot of I always say young lawyers, but new lawyers, right? Doesn't matter your age. It really matters your experience. Is stop when you're ahead. Don't ask the next question or the extra question or the question that's going to take you off a cliff. And she absolutely steps in it. Now, common sense would tell you those are not smart questions because they didn't do what Alex Cox just admittedly did in this self-defense case where he still has to admit that he did pull that trigger and commit that act. He just says it's not criminal. None of these people that are calm there did that. But she kind of got her point across, at least if she wants to make it, and the state can do whatever they want. But she goes too far into it and really ends up stepping into it.
Calm?
They were.
Was the fire department calm?
I didn't interact with him very much. I couldn't answer that.
Your friend, the Wiz, was calm?
Yes, the other officer, yes.
So when I arrived at the scene, things were pretty calm.
Is that a question?
Yes.
Oh, yes, you were calm.
No, I'm saying when I arrived at the scene itself was calm environment.
It was.
Okay. So if I would have been hysterical, that would have been more out of character than if I was calm when everybody else was being calm. Isn't that correct?
Speculation.
First off, it's not really speculation. The judge sustains it, but it's not. She's asking a question. If everybody's calm and one person's freaking out, that would be weirder, right? Well, only one person committed a heinous act here, whether it was justified or not. Horrible, sad, something that should freak you out. Only one person did that. I wouldn't have even objected. I would have let this officer keep answering. He didn't really go into as much detail, but At any point, he could have said, I didn't do anything to my brother-in-law like Alex Cox did. Nothing happened to my husband like it happened to you. So no, it was not normal how you guys were acting. It was weird. It was strange. It was concerning. She was opening the door for him to give his opinion on all of that with these questions she's asking. The state decides to object, so the judge tightens it up a little bit, but I would have let this witness just go.
Same.
So you said that Alex was calm and was holding a towel in his right hand and holding it up to the back of his head. Is that correct?
He did.
And you said, oh, sorry, it's in my other note. Just now that his head had a 1-inch laceration. Is that correct?
Yes,
That's like a cut down his head, 1
It
inch?
is.
Okay. And you said a small knot.
I did.
Is that correct? Okay. And that it was bleeding a little. Is that correct?
Yes,
Okay. And so a small knot is what you declared it, but would you not call it a goose egg?
tomato, tomato.
Okay.
So, a couple things. Why does she care if he calls it a goose egg? Number one. Number two, if you're going to ask the question and make the point, when he says tomato, tomato, follow up and say, meaning we're saying the same thing two different ways, because that's what tomato, tomato means. So yes, it's a goose egg. Yes, it's a bump on his head. If you want to make that point, at least finish it. She didn't really. It could have been confusing still to the jury. King Pine said, Chad is about to roast me, but I don't know much about this case. I kind of feel bad for Lori Vallow having to rep herself. She doesn't have to. She's choosing to. I feel bad for her too. She shouldn't have done this. This was a mistake. But people live with the consequences of their decisions, right? I mean, we know this. That's the case. Somebody else in the chat asked if this was another Grease shirt. This is not a Grease shirt. This is my Masters Week shirt, and it's sponsored by King Pine here. Masters Week. Everybody let me know who you got in the chat if you do follow golf. I'm pumped. I'm excited. I know who I think's going to win, but I'll save it.
Did Alex ask for medical treatment?
He did not.
How many times did you ask him if he needed medical treatment?
I think 3 times.
Okay. And there was EMS right there next to you?
Yes,
So an EMS person could have just come over and checked the back of his head pretty easily, yeah?
yes,
Yes. But no one asked anybody to do that? Correct?
correct.
Okay. And he didn't seem disoriented to you at all?
No,
So you didn't think he needed any kind of medical attention at the time?
no,
And he didn't ask for any at the time?
correct. He did not.
And you didn't supply any at the time?
Correct.
Okay. The EMT was right there next to you?
Yes,
Okay.
This kind of feels like she's making it seem like it was somebody else's fault than Alex Cox that he didn't seek medical attention. First off, just because you didn't seek medical attention doesn't mean you didn't get hit. But I would think at the same time, the state's kind of argument that a semi-pro baseball player hitting you with the bat probably would hurt. Doesn't have to be a direct hit, right? It could have been he, grazed me or whatever, or swung, kind of hit me and I hit my head on something else. I don't know. There's just so many explanations for that. But there was an injury confirmed, whether he sought medical treatment or not. That probably went into the analysis of determining whether or not this was self-defense for law enforcement and for the jury. And I think she did a good enough point to say there was a 1-inch laceration on his head. There was a bump or a goose egg, tomato, tomato on his head. She did a good job enough getting that information into evidence. The state can say it was fake, it was planted, it was staged. Fine. But you've got it in there that people are reporting that day they saw the injury on Alex Cox's head.
That's another thing that you said, calm and nonchalant. Is that correct? You
Yes.
stated that Alex was nonchalant. What is your definition of nonchalant?
kind of like how I am now. I don't have a lot of emotion. I'm not afraid, just nonchalant.
Is that your typical demeanor?
I guess it depends on the situation and the circumstance.
I mean, this can be a stressful situation, right? So it's your demeanor right now.
It is.
Testifying in court can be a stressful.
Again, I think she feels like she's doing better with this than she is. She really wants to go into the nonchalant, and it's a situation where these witnesses could have really steamrolled her from it. And I was waiting for it to happen and it didn't until redirect. All right, Mags, I see the chat. I love you guys. You're my people. We have community here. We do some life together here as we talk true crime together. I will not be saying any of the such or putting any chats on the screen that I find to go against everything I believe in, which is I bleed garnet and gold, gold Knowles. I don't care what else is happening in the sports world. That's where I will sit and stay and live forever. Okay. And if you guys aren't seeing the chats, just ignore them. It's nothing you need to see in there.
Situation.
I guess it can be.
So if that was Alex's normal demeanor, then it wouldn't be out of the ordinary for him to be nonchalant.
Objection, speculation.
Allow it.
It's not speculation. She said, your natural demeanor is like this, and this is how you're acting, even though it's stressful in court. So if Alex's natural demeanor is that, it would be normal for him to act like that. The judge allows it. This witness should have said, no. If this happened to me, somebody who is normally nonchalant, I would be freaking out if I just had to do this to my brother-in-law in front of my niece and sister. I would be freaking out. I was waiting for one of them to bury her as she just continued to go with this line of questioning. She made her point. Maybe it wasn't so weird that he was nonchalant is the point she was trying to make. She made it. She should have moved on.
Allow the answer. He doesn't know the demeanor, but you can answer.
Can you ask the question again?
Yeah, so if Alex's normal demeanor was like your normal demeanor, and even in a stressful situation, if he was nonchalant, it wouldn't be out of the ordinary for him to be nonchalant again, because that's his normal demeanor. Correct?
Objection to compound question.
I'll sustain that objection.
You mentioned that I had parked across the street. Is that correct?
Yes.
Why did I have to park across the street?
I don't know.
So we saw on the body cam, right, that there was a huge fire truck, correct?
Yes.
There was police cars, correct?
Yes.
There was a CSI van, correct?
She was parked somewhere. I don't know where.
Next to the house, kind of, I guess, south of the house. So there was nowhere to park except for across the street. Is that correct?
No,
That's not correct?
that is not correct.
Where else could I have parked?
Well, the street's long. You could have parked anywhere along the street. You could have parked on the other street. That's where I parked. Or you could park on the other side of the street, south of the home, where there was plenty of parking. So there was other options to park.
But I parked as close as I could to the scene so that I could come talk to you. Is that correct?
Speculation, testifying.
Sustain.
So now she's testifying to what she did, why she did it, what she saw there. Not incredibly important to this case, but still a good objection by the prosecutor because you don't want her to get into the habit of doing that, of determining what she is going to say, what she's not going to say, what she's going to connect and not connect. Michelle said, I think some of the problem she's going to have is how much evidence she wants to bring in via hearsay, whereas a lawyer would know how to bring things in. I do think the prosecution got a bit into the mud. I agree with you. And we're going to talk about hearsay once Lori Vallow gets to those issues. Maria said, we love our Knowles loving lawyer. Yes. And I love all of you guys, no matter what school you root for. I just won't be saying anything or promoting anything of the such here on this channel. I'm all for open communication and disagreeing. That's where I draw the line, right? Is my allegiance to Florida State. That'll never change and never be stained.
So we can agree that there were lots of police vehicles blocking the house. Is that correct?
Emergency vehicles.
Correct.
Yes.
Yes, emergency, police, fire, CSI, all were there, correct?
Yes.
Okay. But even though all of those things were there, the scene was not chaotic. Is that correct?
Correct.
It was a very calm scene that day.
Objection asked and answered.
Sustain.
Do you know how hot it was that day?
No, but it was hot.
It was hot.
The confirmation giggle, it was hot, is little. It's just something very small, right? But to me, you're not a lawyer. This isn't your job. You're not building rapport with the jury. This is your life. Your husband's life affected your kids. Just the giggle is to me something you should not take any part in that in this case. I don't really care what's happening, right? That's just my opinion. Also something I wanted to bring up. I'll save that. I'll save that for another time.
Oh, that's what I was going to ask you. What was the extent of your duties that day? I know that you had arrived on the scene. You said dispatch was about 8:39 a.m. Is that correct?
Yes.
And then it took you about 4 to 5 minutes to arrive.
Yes.
And then you were the first on the scene.
No.
No. Who was the first on the scene? Do you know?
Wiz was.
Oh, that's correct. And then who arrived? How long after he arrived did you arrive? Do you know?
Oh, I was like seconds,
Okay.
maybe 10, 15.
I'm going to jump ahead a little bit just because she repeats herself quite a bit, but
When
Sir,
there's an objection.
I'm sorry.
Wait for the ruling.
Did you have a conversation with Alex on the way to the police station?
Yes.
Objection asked and answered.
And did he express?
Hold on. When
Sir,
there's an objection.
I'm sorry.
Wait for the ruling. I'll sustain the objection, but the answer will stand nonetheless. Go ahead. Next question.
Did he express to you that he kind of felt out of it because he hit?
Hearsay?
Sustain.
Now we start to get into her trying to get hearsay into evidence by reading his report. By the way, throughout this entire cross-examination, she's saying, in your report, you say X. In your report, you say Y. That's actually inappropriate. It's kind of like improper impeachment. You can't really bring up the report to refresh. You can't enter the report because it's full of hearsay. You can't bring up the report to have him refresh his recollection unless he disagrees with what's in his report. So you should ask the question, you did this, you did this, you did that, you did that. By saying you said this in your report, you're improperly bolstering your question so that if he disagrees, the jury can think it comes from his report, even if you misread it. So it's just not the way that it's supposed to happen. And so what she's doing here, she's asking him questions and talking about hearsay that's specifically in his report, which is specifically why the report can't come into evidence. And eventually, when she loses some objections here, she gets frustrated and she says, I'm just reading from his report, which is exactly what you can't do because the jury now might think, this is so unfair. Why won't they let her read from his report? Juries usually think police reports are admissible and that they're perfectly fine to come into evidence. So it's like, that's not fair. Why aren't they letting Lori Vallow read these questions from his report?
When did you make your report about the incident on July 11th, 2019?
I think what was the end of my workday that day, but I stopped and started it numerous times throughout the day.
So did you finish it that day or it still took a few days?
No, I finished at the end of my shift,
By the end of your shift, which was what time that day?
4 o'clock.
Okay. And did you make any revisions to that later on, report that you made in regards to?
And she's even using some of this to bolster, like, you wrote this report, when you wrote it, things like that. Because again, she doesn't know. So it seems like it might be the right thing to do, but it's not.
What?
Well, I had no way to test it, so I have to articulate it that way.
So he was bleeding from the back of the head
He was.
on the right-hand side.
Yes.
Is that correct? Okay. And then was it you on the body cam who briefed the detectives, Detective Moffett and Detective Inklin?
Ask them.
Okay. So your report goes to who after your,
Sorry.
on this case regarding this incident on July 11th?
I did at the time. That's when I walked up to them at the front door area.
Okay. And was Detective Moffett the case agent at that time?
Yes.
Okay. And now it's Detective Duncan, as far as you know?
As far as I know, I don't know for sure, but that's what I've been told.
Okay. And how long do you think that you were at the residence? What was the whole time before you guys left to go to the police station? Do you remember? Do you recall?
No, I do not. It would be in my CAD history on when I transported him from the home to the PD. So I'd have to look at that. And I don't know, 40 minutes, half hour, 40 minutes, something like that.
Now, someone on the video, and I don't remember who it was, but put a phone into a evidence bag. Was that you?
I don't recollect that.
Okay. And then got into the car. Did someone ride with you to the police station from the residence? Just you and Alex were in the car?
Yes,
No other officers?
correct.
But before you got into the car, an officer came over and took his phone, put it in an evidence bag?
You're asking me for recollection. I don't remember that. It's probable because we usually try to bring their property to the area where we're going to. So it's probable.
I just didn't see it in your report, but I saw it on the body cam, so I wondered if you knew. Okay.
Can I object to the defendant testifying?
All right. Please only ask questions.
That was an eye roll for me. Personally, if I was the prosecutor, I would not object there. She's like, I was just confused because you said this or that or whatever she said, right? She wasn't saying, I did this. You weren't there. You didn't see it. I was there. I was saying that's testifying. Lori Vallow was kind of testifying like a lawyer testifies, having a conversation with the witness or saying, I thought I remember you say this or whatever. I would not have done. And I'm trying to give examples of really good objections and where you need to keep it tight, and other ones that I probably wouldn't do with a pro se defendant. With a criminal defense attorney, totally fine.
Sure.
When you make statements about what you saw or heard, that's testimony.
I apologize, Your Honor.
Go ahead.
Not handcuffed, is that correct?
Yes, it is.
And it was just the two of you in the car on the ride there?
And I kind of am skipping ahead because there's just so many times she repeats stuff in long pauses, but she mentions how he took Alex Cox to the police station, not handcuffed, leading to trying to get this jury to understand they all went back home because it was self-defense.
Yes.
Okay, thank you. Then when you arrived at the police station, what happened next?
Walked him up to the room, had him sit down, or I think brought him some water, I think. And the detective was literally behind me. It wasn't very long before he walked into the room.
So then Detective Moffett took over and you were excused?
Yes,
Okay. And then was that the extent of your duty
it was.
at that time? And did you leave the police station after that?
Yes.
Did you stay and observe the interview?
No.
So Detective Moffett took over for you and you departed?
Yes.
Okay, thank you. You said when you spoke to Alex that he was cooperative. Is that correct?
Yes.
Is it possible he could have been in shock?
Objection, speculation.
Sustained.
You know, I don't think that's that bad of a question. And I think if I was the judge or if I was the lawyer, I would have said, Judge, can I lay a little foundation? You've interviewed people out of after traumatic events a lot, right? Sometimes they're in shock, sometimes they're not, right? And okay, fine, you're not an expert on what shock is, but sometimes they're more talkative than others. Are there reasons for that? Do people respond differently to traumatic events? Have you ever had somebody respond in a way where they're not talkative after an event like this, or they are calm, or whatever it may be? Have they presented with shock type symptoms? I think you can get into that if a cop really hasn't interviewed a ton of people after something like this. Now, if you don't know how he's going to answer and he says, actually, no, I have never seen somebody that's as cold and calm as Alex Cox after he did this, well, then you're stuck with that answer and you're screwed. But I kind of think she should have been able to go into this a little bit more.
From your observation, how long did the cut on Alex's head bleed? I mean, you were with him for about 40 minutes, and how long
Terrible question.
do you think it was bleeding?
Well, I couldn't answer that because I wasn't standing in the back of his head when I first made contact with him. So to be honest with you, I don't know when it started. So I don't have the minutes.
Did it appear to be bleeding when he exited the house, or no?
I didn't look at the back of his head right away when he exited the house.
When was the first time that you looked at it? About how long after he exited?
I can't answer time-wise.
Did you ever enter into the house?
No.
You were just there in the front yard
Yes.
the whole time? Okay.
So Martina said, why ask that? I think she's trying to prove he really was hurt bad. It was bleeding for hours. I think that's what she was trying to get at, just not an effective way to do it.
Detectives in the front yard
I'm going to sustain the objection.
and gave them your synopsis of what had happened. You said they got into a domestic fight consisted,
Objection.
I'm sorry,
I'm going to sustain the objection.
what was the legal objection?
Hearsay.
Hearsay.
Oh, I was just reading his report. Okay.
Then objection, no question.
Please ask your next question.
All right. So she wanted to get into a domestic issue, which is what she said in her opening. There was a domestic issue between Charles and Tylee, and she wanted to get out that had been relayed to this cop, and this cop related to other cops. That's clearly hearsay, but that would have been a very good point and big point for Lori Vallow. So a really good objection, timely objection. Then Lori Vallow follows it up with, I'm just reading his report, Judge, again, to make it seem like they're hiding something from the jury. They don't want the jury to know the real story. So that was an effective spot to go, but you got to know you can't do it that way. You just would never be able to do it that way. And you can get into potentially effect on the listener. Like when you respond to a scene, it's important to know what you're responding to, right? What were you responding to here? Objection, hearsay. It's not for the truth of the matter asserted, Judge. It's what actions was he going to take? The effect on the listener and the next steps he took in his police work was to show up to a scene where he thought there was a domestic violence issue. And then how do you deal with that? Tensions may be high, separate people, whatever it may be. So there are ways to try to get there, but not the way she did it.
You said in your report that at one point, Alex's niece grabbed the bat.
Objection,
Hold on.
hearsay,
That's
improper
hearsay.
question.
Okay. You can't ask hearsay. Please ask your next question.
You get what she's trying to do. just the wrong way. And once again, it can be very frustrating, but this is part of what being a lawyer is, and understanding the rules and how to get the information the proper and reliable way.
Did Alex tell you that he got hit in the head with the bat?
Objection, Your Honor. Hearsay prior ruling.
Yeah, it's sustained. You can't ask questions of what Alex said.
So you observed that he had this bump on his head, but you didn't know how he got it. Is that correct?
No, that's not correct.
You did know how he got it. Is that correct?
I was told how he got it, which is different than me knowing how he got it, if that makes any sense.
Correct. You did not witness it, is what you're saying.
Correct.
But you knew that he had an injury to the back of his head on the right side.
I did.
Correct. Okay. And how did you obtain that information?
Your Honor.
You can't answer if it calls for hearsay.
Did you observe the next door neighbor come out in her nightgown to speak to me?
I did.
And then there was another neighbor on the other side that came out that you told him to go back into his house? Is that
Well, he was
correct?
a neighbor, but it was just some guy. Yeah, I assumed he was a neighbor.
Right. So they had blocked off the street so the neighbors couldn't really exit the neighborhood. They couldn't go to school or work, or it's kind of an issue there.
Not really. I mean, when one car told us the layout of the neighborhood, then we realized that was the only person that wanted to exit. They told us they couldn't exit, so we just fixed it. So anyone else could leave.
Right. But they were trying to come up to me to find out what was happening.
Objection,
Okay.
speculation, hearsay.
I'll sustain the objection. Let's take our afternoon break.
So the judge takes a break and explains to Lori Vallow what you can and can't ask as far as hearsay goes to hopefully tighten this up. I Love Godzilla said, Pita, if you were the judge, would you excuse the jury and tell her to stop mentioning the report? Not without an objection from the state. I probably wouldn't. There's a balancing act here again with the pro se defendant. You want them to stay on track. You want them to be organized. And sometimes if they start at the top of the police report, confirm everything the cop said and read their way down outside of hearsay and other things that are objectionable or that you ruled are inadmissible, let them go down and let them be structured and then be done, as opposed to them being all over the place, fumbling around looking for documents. You guys may have no idea how bad this can look, right? We've seen Darrell Brooks, but when people actually try, like Lori Vallow is trying, I don't think Darrell Brooks fully tried, but when people actually try, but they don't know what they're doing and they're unorganized and they have papers everywhere, it can take forever. It can be miserable. They can all lose just the same, but it can be so incredibly laborious to watch a criminal defendant do this. So that might be why they're allowing her to do it this way, to keep it kind of structured and going, but they are sustaining a lot of the hearsay objections, which are the issues. Laura said, will the jury be able to hear about her other convictions? If she testifies, the judge said he's going to let the states ask, you have been convicted of 2 other felonies, but that's all they're going to know as of right now, unless Lori Vallow opens the door, is my understanding about how the pretrial rulings went. But we'll still wait and see if any of that actually comes out. So right after they take this break to explain to Lori Vallow about hearsay, what's admissible, what's not admissible, here's how she starts.
Is that correct?
Yes.
And what did you tell them in that briefing?
Objection, hearsay.
Sustained.
Did you see the judge's face? Watch the judge. He goes, like, I just told you can't do that.
Just a couple more things. You mentioned that you briefed the detectives. Is that correct?
Yes.
And what did you tell them in that briefing?
Objection, hearsay.
Sustained.
Are his statements hearsay as well, Your Honor?
Any state out of court statement is hearsay unless there's an exception under, or it's non-hearsay under the rules. So yes, his out of court statements are hearsay.
Every out of court statement is not hearsay, not even close. But I get what the judge is trying to do. He's trying to simplify it, not go overboard in front of the jury. But there are plenty of out of court statements that are in fact not hearsay, which he does say exceptions, or they're just not hearsay. But the answer is yes. Even his statements out of court can be hearsay, which I will just tell you, no making fun of Lori Vallow here. A lot of lawyers and people struggle with that. And in law school, the concept of, but they said it, so why can't I just ask? And sometimes those statements might not be hearsay, but just because the person on the stand said it out of court doesn't mean it's not hearsay. A lot of double negatives there, but it confuses a lot of people, not just Lori Vallow. I'll just say that.
Go ahead.
But you did brief the detectives before you headed to the police station? Is that correct?
I did.
And who was there? Do you remember?
Nate Moffett, Cassie, I think my
Is that
sergeant.
Detective England? I'm sorry. I don't want to interrupt you.
No.
Oh,
And just off recollection, I think there was another one, but off of recollection, I don't remember.
and that was about how long before you left to go to the police station?
Ten minutes, maybe?
And how long do you think you were speaking with them?
Under a minute.
Under a minute
Yes,
for the briefing?
yes.
I see a bunch of people saying the judge is annoyed, the judge is not annoyed, the judge is very patient. I think he's actually a pretty good balance of holding your feet to the fire, moving this trial, but not, especially in front of the jury, not making it look like he's too annoyed, not, reprimanding her, yelling at her, things like that. I think he's been a good balance so far.
Did you meet with the prosecutor to go over your testimony today?
A very common question lawyers ask, right? She's probably heard her lawyers ask this a bunch of different ways, a bunch of different times. So she does it to make the point across. Will she connect it later in closing? We'll see. But all these cops and prosecutors conspiring against me, meeting and making sure all their statements line up, making it sound really nefarious.
I did.
When was that?
2 weeks ago, maybe?
How long did that meeting last?
Probably around an hour total.
Did you review this report before you came to testify today as well?
I did.
And it was not part of your duty to check anything in the perimeter? You weren't looking for evidence, you were just dealing with the shooter? Is that correct?
Well, not just the shooter, but scene management, making sure the resources were en route. But yes, managed.
What all does that entail, scene management?
Well,
What else?
make sure I had a supervisor and
Is there en route, do you know?
Bill Nacella, my sergeant. He needed to just leave the area. This didn't concern him. And then you and your daughter walked up to me and I just asked you to go back to your car.
Did you have any conversations with your supervisor when he arrived?
I did.
When was that?
At some point between me arriving on scene and me leaving the scene.
Closer to arriving or closer to leaving? Maybe.
Chocolate milkshakes is about halftime.
Okay. How long do you think that conversation was?
Well, you saw it on the body worn camera, so a minute and a half maybe.
And he was just checking in with you to make sure everything was going well, that you were scene managing. Is that correct?
Objection, relevance, and hearsay.
I had a lawyer once giving a speech and he was like, objection, boring. The defense lawyer was so boring. It was a civil case and he got reprimanded by the judge for saying it. But it was like, she's asking some of this stuff that, is it relevant? I could probably see a way it's relevant. They're getting their story straight, talking to the cops. She wants to show, here's what I would say. Everything that happened at the scene, everything the cops did is relevant because they all concluded it was self-defense. So it's not like one cop came in there and decided self-defense. No. Every cop came, they saw this, they talked to people, they saw things, they talked to each other, they talked to witnesses, they all got together, they talked, briefed each other, looked at pictures, looked at the wounds on Alex, on Charles, and they all came to the conclusion that it was self-defense. That's what I'm trying to build here, Judge. That's why it's relevant.
Or he can answer.
I was briefing him on what I knew thus far, what I was told.
And that was less than a minute?
Objection, asked and answered.
Sustained.
So it took less than a minute to brief him on everything that had happened that day so far?
Objection, asked and answered.
Sustained.
And it took less than a minute to brief the detectives as well of what happened that day?
An objection, asked and answered.
I'll allow that one. Go ahead.
Not what happened, what my portion was and what I knew happened.
So what you wrote in your report, basically, what you were told. Is that correct?
Yes.
So it took you 3 pages to write what you were told, but it took you less than a minute to discuss that with the detectives. Is that correct?
Yes.
That's what she was getting at. That was her peak moment, right? That was the climax of this story, is that, haha, how did you tell him in 1 minute what it took you 3 pages to write? It's like, okay, I'm not sure what that proves, but I think the secondary purpose is you put all this in your report, you talk to everybody, it's in your report. I was trying to read your report, they wouldn't let me, right? Which again, not an appropriate argument, but feels like that's kind of the best thing that she got from that whole line of questioning. Now what we're going to do is, this is kind of fun. We don't always get to do this. I have about 15 minutes left, so we can go a little bit over an hour. And I think this cross is about 15 or 20 minutes, but we are actually going to jump to today. Right now, almost live. We're a little behind court because we have been doing this video instead. But this Chandler Fire Department employee has testifying, and basically most of his testifying was about the scene and how Charles was and how the wounds looked. Specifically, it definitely did not look or feel like, to him, an expert, that anybody had done CPR. So even though it sounded like they said they did CPR, but it didn't look like anybody performed CPR. Were they lying? Here's what it would have looked like, and it didn't look like that. So even if it was self-defense the first shots, why did they wait so long and not perform CPR? Could they have saved him? Things like that, right? So this is the very beginning of today. So I see Trogger saying, no, I haven't watched today yet. We are going to watch like the first 15, 20 minutes of today. Then we're going to be done, and you guys can go watch the rest of today. It's not spoilers. It's literally happening right now because it's on a tape delay of 30 minutes, and it's in Arizona, and they don't start on time. They had a juror issue. I heard they struck a juror this morning, which is interesting. And they only have 2 alternates left, which could be a problem. King Pine said, you're the best. And the chat took it easy on me. I've got Bryson winning his first Masters. That would be fun. I hope it's a huge name, right? Big storylines of some sort, but I think I'm going with Scotty. Again, I think I'm going with Scotty to repeat. I think he's coming up, and this just feels like his spot. So we'll see. We'll see. All right, let's take a listen for the first time. I have not heard this. I don't know what she's going to ask. I don't know how it's going to go. We're going to react to it together for the first time here. All right, there's no...
What?
Walk into the house, proceeded for
I heard on Twitter that there were some sound issues this morning, so we're going to do it the best we can.
forward, saw the patient on the floor to the right, proceeded to the patient to start an assessment and evaluation.
And then Captain Keller had already come in.
I'm pretty confident, yes, he would have been quicker getting off the truck and inside.
And so you did your assessment, and then what?
My assessment revealed that he was unresponsive, no pulse, no breathing, so I would have started CPR, started chest compressions.
Did you do that with his shirt on?
I would have lifted that out of the way so I could find the proper landmarks.
So you had said that you saw that there was, let's see, 2 gunshot wounds. Is that correct?
Yes.
And then you saw that through the shirt? Or how did you assess that when you first entered? That's my question.
Once I'm doing CPR, I can see 2 bullet holes in the shirt. I can see that on the chest and on the abdomen. I can see the wounds as I'm looking at the chest and doing chest compressions.
Okay. And then he had on what color shirt?
I wouldn't have recalled other than, I guess, the video yesterday. I think it was a dark colored shirt I think we saw on the screen.
And so you had talked yesterday about the blood being more blood on chest, not pooled around your knees, right? Is that correct?
Correct.
And so with the dark shirt, was it hard to see the blood? I'm kind of trying to see what you saw when you entered.
I remember seeing blood on the chest. I remember not seeing blood on the abdomen.
And there were holes in the shirt, 2 holes in the front side?
I would, best of my call, yes.
Okay. And when did you cut off the shirt, and how does that procedure work?
I continue doing
Again, a complete deposition question, not a trial question. Unless there is a problem with how he did it or with the procedure that he used, a defense lawyer is never going to ask this question.
CPR, chest compressions. One of my other colleagues would have cut that off. And knowing that the shirt maybe is potentially evidence, that's why I said to her, don't cut through where the holes are. So she could have cut down the side instead of on the top of the body.
And do you use like a special scissors or something for that?
Yeah, we
Or-
have some trauma shears in our equipment.
Okay. And who was that? Was that Phelps
No purpose to that question. There's no, at least that I've heard yet.
or,
I believe that was firefighter Kaczynski.
okay, Kaczynski, that's one I didn't have. So who all was sitting there with you? That,
Kaczynski, that's one I didn't have. Again, in a depot, that's a great question. Get all of the names, all the information, everybody you could possibly depose. You need everything in a deposition. In a trial, it's a bit of a waste of time.
that was on scene at that time?
Firefighter Fife would have been there.
Mhm.
Firefighter Kaczynski, the three of us, kind of like we saw in the video or I guess the picture yesterday. All three of us around the patient, while Captain Keller was standing back a little bit, like you saw in the picture.
Okay. You said that you had been a CPR instructor for 12 years. Is that correct?
Yes.
Okay. And was that for the last 12 years or 12 years ago?
Approximate dates 2004 to 2016, let's say.
Okay. And so have you taught people who have never done CPR before?
Have I taught those? Yes,
Right. And not just like people renewing their certification, but both.
correct.
Okay. How many people would you say that you've taught that have never done CPR before?
Never done CPR, and it's probably in the hundreds over that long of doing that.
So you'd be familiar with how a first timer would react.
Yeah, you try to forewarn them what to expect.
Okay. So these first timers, they have to be taught the appropriate place to place their hands. Would that be fair?
That is part of the course, yes.
And so do you show them or do you just tell them in class where to put their hands?
It's a video-based system through American Heart. There's a curriculum that we would have been following.
Okay. So if you could only tell them like over the phone, that might be difficult for them to know the correct placement of their hands if they've never done it before.
I guess it depends on the instructions that the dispatcher gave. Ultimately, if I was telling somebody over the phone, you want to put your hands on their chest, on the lower part of the chest. It's that kind of simple, so to speak.
So here's what I'll say. What she's getting at, based on his direct, I think, is that Alex did try to do CPR. He just did it wrong because he's never done it before. And all he was being explained how to do it was over the phone, not by video or somebody showing. That's her, argument. Do I think it's super effective? No, but it is an issue that she has spotted that she's trying to deal with. And you guys let me know in the chat. If you were a juror, would you be like, oh, okay, that makes sense. Maybe he did do CPR. He just did it wrong. That's why there was no indication from this CPR expert that somebody else had tried to do CPR. I think it's the right thing to try and attack and deal with. I don't know how CPR is not rocket science, right? And I think that telling somebody approximately doesn't mean you would do it perfectly, but I don't think you would be like, doing compressions on somebody's neck or at their belly button or things like that, but I don't know. I think it was the right decision and strategy to go that route again, but actually doing it effectively is difficult. What do you make of the pros and cons ad nauseum question regarding CPR? So I just told you kind of my thoughts of how Lori Vallow dealt with it, because I do think it does show a bit of intent and evil intent for frankly on Alex Cox if he didn't even try to do CPR and then he lied about it and said that he did, aka some issues with that potentially with Sarah Boone. The same kind of line of questioning came out. So I do think that could be potentially important for jurors. Like, wait a second, he didn't even try, yet he told him he did. Was he staging this? Was he setting it up to try and make it look like self-defense?
Okay. But without the video, if you were teaching a class and you didn't have the video, it might be difficult, right? For a bunch of first timers?
Objection, speculation.
Overruled. You can answer.
Did me answer? Okay. Sorry. Can you repeat the question then?
Yeah, so it might be difficult. If you didn't have the video, it might be difficult, for a bunch of first timers to know exactly what to do if you just had to tell them middle of the chest, lower chest.
You could obviously show on a person, you could show on yourself.
If you couldn't show them and you could only tell them, could it be difficult?
Like, suppose it's possible depending on the person.
Okay.
She kind of got the answer she wanted, right? She stuck with it. By the way, something else I will notice, this is like a thing for when you get dementia and, just other things people ask, even some IQ tests. It's like you're told things, you have to remember it, and then they say it at the end. So many lawyers have so many things going on in their mind that when they ask a question, it's rejected, overruled, and the witness has to repeat the question. They either can't repeat it, don't remember what they say, or ask the court reporter to read it out. A couple times in this trial, she has remembered exactly what she asked and asked it again. I just want to kind of point that out. Peter, wouldn't that be hearsay, Alex saying he did CPR or didn't? Not if they're not using it for the truth of the matter asserted, right?
That's fair. So do you think that your CPR class would be fairly successful if you had no visuals?
Objection, relevance, speculation.
One question too many, Ms. Vallow. You should have stopped right when he gave you the answer you wanted, that, yes, I suppose it could be difficult based on the individual. Just move on. You got your answer. And in closing, you could say, even the CPR expert said, if you don't have visuals, depending on the individual, like Alex, who had never done CPR before, objection, she's testifying, judge, facts not in evidence if they don't come in. But again, you got what you needed to connect it in closing, yet, of course, she continues on.
Yeah. Next question.
I got it, Your Honor. So if a person had never done it before and was just told how to do it, is it possible that they might not be acquainted with where to put their hands?
It's possible.
And it would also be possible that they might not do it properly.
That could be possible too.
And right
She got her answer 2 more times. She got her answer 3 times now.
now, when you're teaching CPR, and I didn't say you are teaching right now, but if you're teaching a class, are they just doing percussions now? There's no breathing in the mouth. Is that correct?
It's going to depend on the level of the class. As far as the lay rescuer, people that have never done it before, that just want to have the training. It's evolved and we're teaching compression only. That is a form of CPR now also, just doing chest compressions.
And how long do you teach to do that for? How long of a period before you take a rest? Or
Well, it varies depending on if the patient is an adult or a child. There are different guidelines that American Heart offers. So in those courses, they're getting to learn information for adults and children and infants also.
correct, right. So for an adult, how long? Like 30, 100, 150? It's been a while, so just wondering.
With an adult, they're also taught they need to call for help right away also. So that's a factor. Are they alone? Is somebody else?
I could be wrong. Chad, help me out. How does this help her case? I get why asking those other questions, like Alex may not have known what he was doing. How does this help her case?
Able to call? Can they call, put the phone on speaker, start, while talking to 911? And then they would just keep going until help arrives.
So there's no timing, like you take a 10-second break, you just do compressions?
Not for that type of level of CPR, there wasn't.
Okay. So it's helpful if you had someone there that you could like take turns, like I'll do 100 and then you do 100, because it's kind of exhausting, right?
Objection, compound question, relevance.
I'll sustain it as the compound question. You can re-ask the question.
Definitely relevant.
Well, ask it in a different way. Go ahead.
So how long did you administer the CPR before you did the flip over? How long do you think that was?
Before we rolled him to look at the back, is that what you're-
Correct. Yes, that's correct.
I would estimate maybe up to a minute.
Okay. And then were you counting compressions? Is that what you were doing during that time, or do you not count? You just do it for a certain amount of time?
I don't recall if I was counting. I mean, I was doing the chest compressions while waiting for the rest of the team to arrive and for us to continue assessing, see if we're going to continue to work the patient and utilize more equipment.
And there were 3 of you there?
4 total, but 3 by the patient.
Okay. And then you could take turns, right? Like trade off if you needed to?
If we needed to, yes.
So that'd be a lot easier than when you're just there by yourself. Would you agree?
Yes.
Okay. And do you know how long, after the rolling over that you started doing compressions again? Is that correct?
Yes.
That's what I had.
Yes, I believe so.
And how long did you do that for?
I would estimate maybe upwards of another minute.
Idiot wind. I didn't know that. That seems crazy to me, because I will just tell you, there are people sitting in jury selection that they are not being honest with you. Like, you just know they're not. And they say certain things, but, oh yeah, I can be fair and impartial. And you can't prove it to the other side or to the judge. So if you can't strike them for cause, that's what the preemptory is really for a lot of times. And those are gone in Arizona. Like, it's like same places that some jurisdictions don't allow lawyers to ask any questions. I just think that completely changes the jury system. That's mind-boggling to me. Mind-boggling. And I agree with the second part of your comment.
So maybe 2 minutes total?
During that sequence, yes.
And was there another sequence?
At some point, we would have stopped doing chest compressions so we could evaluate the heart rhythm. That's on the heart monitor.
with the heart
And
monitor?
we can't be doing compressions to evaluate that.
Okay. And then you didn't continue compressions after the heart monitor at all?
From what I recall, I resumed again in brief discussion as far as what direction we were going to go.
And what were the results of the heart monitor?
There was no electrical activity.
And how long was the heart monitor applied compared to when you started the first compressions?
I'm not sure if I understand the question. Maybe you can reword it or.
Sure. How far into your treatment, I should say, did you guys stop and do the heart monitor?
I would estimate that the monitor probably was on within 2 minutes of making patient contact.
And idiot wind, it's almost like that's the point of like traumatic events that really affect people's lives. Is that's what's so crazy about it, is people don't act how they normally do. So to just have something like this happen and be like, well, that's how I always act, and it didn't change how I always act, is wild. Michelle said, I meant the prosecutor's question about CPR in the mud. Yeah, I thought it was a little too much. I think, again, she got that it definitely didn't seem like to him that anybody had tried CPR, because you would see in the chest, you'd be able to tell there'd be blood places. The other officer said the same thing. Yeah, I understand why it's important. Probably could have trimmed it up a little bit, but hindsight's 2020. Monday morning quarterback, I could watch myself at trial and be like, you probably could have done this a little different every time.
Okay. And how long does that take?
To do what? To put it on?
Well, yeah, to put it on, get a reading, and decide what you're going to do next.
It could take, you got to turn it on, open up a compartment to get the pads out of that compartment. You got to open that packaging to be able to apply it to the patient's chest area. If the chest is wet, which there's some blood, you need to dry that so it's going to adhere more properly, read more properly. So you could be looking at 30 seconds to a minute possibly of working through that.
Okay. And did you have to do that in this case, is remove blood to stick them on?
I would assume so, but I was doing chest compressions, so that would have been one of the other two firefighters kind of working through that.
Okay. So I understand correctly, you said when you rolled him over, did you cut the shirt in the back also to see the exit wounds? Is that?
No, we only had to cut the shirt one time. That was when he was still laying on his back. You cut it down the side and that opens it up to where then you can remove it from the body, pull it off.
So you did pull it off completely at some point?
More than likely, I would say yes. That's typically what we would do.
Okay. But you don't remember if you did that in this case?
I know that I didn't do that because I was doing chest compressions. So I would assume one of my colleagues did that completely. That's typically what we do.
Okay.
A couple interesting comments here. Eric said, I would say I have always been the calm one in emergencies. One of the reasons I became a paramedic, even when the person hurt was one of my kids, I'm calm. I understand that. And I think that's great. And I do think there are people, on every side of the spectrum that are more calm than others. I do think that this is about as extreme of something that you could be part of, right? Husband attacking your daughter and your brother shooting him twice. He ends up dead. Like, it's not like somebody got hurt or in a car accident or something like that, right? I mean, this is about as high of a level as you can get and still calm. But maybe if you were on the jury, you'd be like, yeah, I think it's fine. I think people can be that calm. Also, you're a paramedic. Chris R. said, first responders are calm. You learn to filter out focus. A life depends on it, and it's your job, right? It's a little different. Paramedics doing their job. That's why, Eric said it was also including his kid. But when it's your job, just like lawyers, like my life is not on the line, even though my clients is, and I take it very seriously and I do my absolute best. But it is very different for Lori Vallow to be doing it for herself than for me to be doing it for like somebody like Lori Vallow, right? All right, we've got about 5 minutes left. We've got a hard out here at 3:15. So about 5 minutes left. We'll listen to as much as we can.
And so you're back to doing the compressions for the third time, and then you stopped that at some point. Was there another procedure after that?
No, at that point in time is when we would have called the patient.
And who announces that?
Ultimately, I remember our captain, since he's in charge of the crew, would be considered the lead medic. He has the most experience. He's also charting the call, kind of running it, kind of made that final decision.
And that would be Captain Keller? I'm sorry, I didn't want to interrupt you.
Yes, correct.
And then he did call it at, do you know what time?
It would have, I don't have it memorized. No, it would have been like in the charting that he was doing.
And who documents that?
He would have documented
He would have
that.
done it. In preparation for your testimony here today, did you review the 911 call at all?
Not in preparation for today. Not the actual audio. No,
No.
no, not today. Not for this.
What did you
Live trials, even sped up, are not fast enough pace for me, right? I feel like I need to be doing 3 things right now at once. As somebody said, Peter's getting bored. I literally feel like I need to be doing 3 other things at once right now, but I'm going to focus in. It's only a couple minutes left. And I'm just reading the chat almost more than I'm listening. I'm doing both at the same time, but it's so funny. This is why I can't stream. It's one of the 50 reasons why I can't stream. And of course, because I have a real life appointment at 3:15.
review for today?
I was able to look at the incident times were dispatched by Phoenix Fire Department. I was able to look at the paper documentation.
Does that chart consist of?
There would be scene times, date, time, address, patient information, name, address, maybe medical history, things that we, a narrative of what we discovered, what we've done, treatments that we've done. The heart rhythm from the monitor gets attached to it.
So that would all be in Captain Keller's report?
Correct.
And you did take a look at that in preparation for today?
Yes.
And did you write a report regarding this incident?
No.
You don't have to document anything?
Just one person documents the call.
So for all of the people that were there from fire?
Correct.
Okay. So that's the total report. You just give your input to him and he puts it into the report?
Correct.
And that's the same for the other 2 firefighters that were along with you?
That's correct.
Okay. So they don't have their own individual reports as well?
No.
Okay. And what time were you dismissed from the scene?
I mean, we probably only remained an additional 5 to 10 minutes. The chart would have that time. I don't necessarily have it by memory.
So how long were you at the scene total? Like,
If I had to estimate without looking at it, I would say approximately 20, 25 minutes.
I just feel like none of this is important. Maria, there's 3 times speed now. I've heard that and I have tried it. I prefer 2 still. 2 is kind of like the max perfect for me where I can still get all the information I need to prep for these streams while I'm working and listening to it on 2 time. 3 times, sometimes it feels like they skip words sometimes on 3 times speed.
okay. And then you were like the driver of the truck, right? Was that your responsibility? So you drove in and then did you drive out as well?
Correct.
Okay. So if you guys arrived around 8:41 or something like that, then you left around 25 minutes later? Would that be accurate?
I guess when I was giving that estimate of like the 2025, I was even including like our dispatch time from the time we're dispatched driving to the scene. So if you're wanting to know actual on scene time, it might be closer instead of the 20 to 25, it might be more of a closer to 20 solid. Like
20 minutes?
Yeah.
Okay. And is that typical for a call?
it can vary depending on the calls.
Okay. So what other things did you do in that 20 minutes besides administer to the patient?
Total deposition question.
Including in that time while we're staged around the corner, waiting for PD to arrive, then for PD to clear the scene, for us to drive to the scene. There's the time with the patient, and then there's going to be the cleanup afterwards. Removing our equipment, going outside. Maybe the equipment needs to be cleaned, restocked, ready for another call. So when we drive away, we're ready to respond to another emergency and then drive away.
Okay. So when you were done with the patient and you were going through that procedure of cleaning, were you in the house or did you exit the house?
We'll remove all of our stuff and we'll go outside, typically to the front bumper of the fire truck.
And then what do you do?
We have cleaning chemicals on the truck that we could get out to, clean our equipment up to reuse it. We've got cabinet with restock to be able to restock anything that might need to be. So we'll take care of those things to be ready to respond to another call.
Okay. And while you were out front, did you see Alex on the curb?
I did see somebody on the curb, or I don't remember. I remember conversing with any officers on scene. That would have been more Captain Keller, charting, documenting, kind of getting information from them. He would be able to answer that question.
Okay. So did you, was anybody in firefighting on your team, the 4 of you that were there, was anyone asked to take a look at Alex?
We were not.
She could probably use that nobody even, was told to look at him or asked how he was doing. Maybe that's why he didn't seek medical treatment, even though we've seen other testimony.
Let's see. Have you spoken to the media about this case?
Can I object? Relevance?
What's the relevance?
What is the relevance, Your Honor?
Yeah.
Just to know how many times he's given testimony?
Your Honor, I'm
All right,
going to, maybe we can
hold on.
sidebar.
Yeah, I don't want to, all right, let's go on sidebar.
All right. And that's where we will end here, is at this first sidebar where things finally start to get interesting. But unfortunately, it's time for us to go. So thank you guys so much for joining me. Make sure you hit that like button and share with anybody that's following this case. So tonight, after the trial is done being streamed over there in Arizona, they can check it out and let us know what they think of how Lori Vallow is doing so far in this case. But for now and for today, that's all I got. So until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.